Hi, everybody. My name is Renee Reisman. I'm the Educational Programs Coordinator for California Lawyers for the Arts. And welcome to our workshop. Before introducing Carol, I'm going to play a message from our Executive Director, Alma Robinson, that kind of gives you an idea of what CLA is all about.
Hello, my name is Alma Robinson, and I am the Executive Director of California Lawyers for the Arts. CLA is a statewide nonprofit organization that was founded in 1974 to serve artists and arts organizations of all disciplines with advocacy as well as services that provide support with legal and business issues. With staffed offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego, we provide several core services. First, we provide legal counseling to specialized attorneys who provide assistance with a variety of intellectual property questions, as well as contract reviews and negotiations and other important business issues. Depending on the client's financial status, legal assistance may be available on a pro bono or reduced fee basis. We also provide a specialized program that assists independent inventors and small startups with their patent applications. To help with situations involving disputes, we provide a range of alternative services, including negotiations counseling, mediation, and arbitration that can avoid the expense and hassle of going to court. Finally, we offer a full menu of educational programs that include workshops, symposia, and conferences on various legal topics for artists and arts organizations. Many of these programs are posted on our YouTube channel, and we encourage you to use these tools to educate yourself on the legal issues before you reach out for specialized assistance from our organization. Thank you for joining today's program, and please consider joining CLA on our website at www.calawyersforthearts.org so that we can continue to maintain our full range of services. Thank you.
That was a little overview of what California Lawyers for the Arts is and our multiple services. Now, Carol Contes of Guzman Law Group, thank you for joining us today. And I'm so excited for you to go over different agreements for filmmakers.
Thank you. Well, actually, let me just say I'm a solo practitioner. I don't work for the Guzman Law Group. I have my own practice, but I work with the Guzman Law Group and occasionally with other law firms. So I've been doing this for a long time, and it's my pleasure to be here tonight. So thank you all for coming. We're going to start tonight talking about things that I see all the questions that you're all very rightly concerned about. And it's basically for creative people who have created something. And now what do I do to try and get it to be made? So before we go too farther, I want to give you just a little bit of a basis about copyright. Copyright is a statute that we have in America that is very old and has been around for a long time. And Section 17 U.S.C. 106 says that as the owner of a copyright, you have the exclusive right, and I'll read you this list, to reproduce the work, to prepare derivative works, that's like remakes and sequels, to distribute copies of your work, like in a phonograph record, to perform it publicly, to display your work publicly, and in the case of recordings, to record it and display it or to perform it digitally. Now, okay, you all know that. You're a copyright owner. But what's really interesting, I've always found very interesting, if you're a co-author, what rights do co-authors have? So I've used the word author. Basically, there's two kinds of copyright. One is a work of authorship. So if I sit here in my office all alone and I write the great American novel, that's a work of authorship. However, if a publisher pays me to sit at home and write, hopefully, the great American novel, it's going to be a work for hire. And the difference between those two things is ownership. A work of authorship, the author owns it. A work for hire, basically, it's what we shortcut say is the golden rule, the one with the gold rules. Usually, when you are paid to do something, the person who's doing the paying owns the results and proceeds of your work. Now, under the copyright law, in order for there to be any kind of transference of copyright, there needs to be a written document, which is why if any of you have gone to work for a studio or company or whatever, you have a written contract of employment. And somewhere there in the fine print, it talks about work for hire. So we'll put that aside for a minute. Let's talk about works of authorship. Let's say that you and a couple of your friends have sat at home over the course of the pandemic and have come up with a screenplay, and you're co-authors. What I find is very interesting about our copyright law is that each co-owner has the right to exploit the work if, however, they do not diminish it or destroy it. So even though under the copyright laws, co-authors each have the right to publish and to work, in reality, however, no one is going to accept any work without a clean chain of title. So what does that mean? Interestingly enough, the United States of America has a public record at the U.S. Copyright Office. That's www.copyright.gov. And I encourage all of you to go to the copyright website and to learn something about copyright. It's really terrific to know those things. But you can also use the Copyright Office to record documents. So here is what reality is. If you write a screenplay, I will advise you being one person, two people, whoever it is, the authors of that screenplay, to register that screenplay for copyright protection. And it will ask you the questions of who are the authors, and you will establish ownership for public record. And remember that it's very, very important. Then, for instance, if someone wants to buy your screenplay, I guarantee you that that lawyer will have you sign a short document that will be filed in the Copyright Office. Again, it tells the world that they have bought the rights to your screenplay. And then if the movie gets made, the Screen Actors Guild may want to put a lien on that copyright to make sure that their actors get paid. They will file a lien in the U.S. Copyright Office. It's almost like real estate, only for intellectual property. And because we have this public record and it's been used, and America is a leading force in the entertainment business, it's used by companies all around the world. You will see documents there for all sorts of movies that are filed. So what's the point? www.copyright.gov. Know that it exists. There's a lot of great resources there, and that's where you will find the forms that will help you file for copyright. So let's talk about the interesting stuff. Let's just say that you've written your screenplay, and there's two of you, let's say joint authors or three, whatever, and now you want to figure out what to do with it. Well, I've given you a bunch of agreements that are different kinds of agreements that are used to establish rights. Now, I'm going to presume all of you are fairly new to the business in one way or the other, and you may not be represented. So that's always challenging to get your stuff out there and to get people to read it. And you might be afraid. So what's the first thing that will happen? Well, I gave you a submission agreement, and we'll start there. Instead of the collaboration agreement, we're going to start with a submission agreement. That is a document that has been developed over the course of years and is used with all the major companies. And most companies, whether it's a management company, an agency, a studio, a production company, will not even read your work unless you sign a submission agreement. Now, the irony is if your agreement goes to a studio from an agent, they don't ask for these agreements, but they do ask for them basically from strangers. And why do they ask for that? Because they want to protect themselves against lawsuits, is really what it amounts to. And what do these agreements say? These agreements basically say, you understand that you're submitting this, that we have lots of projects that are probably just like this and have similar elements to this. However, in the event that we choose to utilize this property and there's protected intellectual property in it, we will deal with you. But by the way, you basically are signing away all of your rights to sue. It says, except as otherwise provided in the agreement, I hereby release you from claims, demands, liabilities. They're just trying to get rid of nuisance lawsuits. That's what this is about. Should you sign it? Most of the time, I'm going to say yes, because they're not going to read it without it. But the companies that are asking you to sign this, they're going to, the one that I have here is from one of the major agencies. They're legitimate. If they're interested in you, they're not trying to steal your material. They're just trying to protect themselves. So when you see the submission agreement, don't get overly nervous, but I do say you need to have a lawyer look at it to make sure that there are the right provisions in there that say, if we want to buy your intellectual property, we're going to sit down and negotiate with you. That's the important thing. So that's what a submission agreement is. And again, they run the gamut. Some of these things are online. I get nervous with submission agreements. I always read them carefully. That's all I can tell you, very carefully. But let's go back to you sitting in your living room and talking and coming up with a screenplay, and three of you get together, or you come up with a treatment, you come up with an idea for a series, whatever that is. The first thing I would tell you is that you want to have protection for your intellectual property. Why? I'm taking a deep breath. We're in a very interesting time in the entertainment business. What we are seeing is vertical integration of companies, and that means that they are developers, producers, distributors, and exhibitors. They control it all, the whole stream. And now it's not just in America, it's worldwide because with digital technology. And most of the time, I sound like I'm picking on the streamers, but it's just a reality. They're like the studios of the old time. When you go there, by the time they give you money for development and you look at all the paperwork, they own everything. What you want to make sure is that you have at least established ownership in your primary intellectual property so that you are properly compensated for it. Whether you're selling it to Amazon or you're selling it to a producer next door. So very important, register for copyright. What's the agreement between the three of you that have come up with this brilliant idea for a series? Now I'm saying turn to a collaboration agreement. And this is something that is based on a real idea, a real interesting idea with three young writer producers who had this idea of using virtual reality in a historical concept. And what was interesting about how they behaved, they each gave their own unique set of intellectual property to the project. If you think about it, one was experienced in virtual reality. The other one actually was a historian, and the other one was more of a writer. So each was giving their unique vision, but when it came to putting together the treatment and the intellectual property upon which a series would be based, they were pretty much equal partners here. So what does this agreement look like? Now, the first thing is, I'm going to go through the contract. The first thing is we identify the parties. All these whereas clauses, they basically are explaining what has happened and why we're doing this. They're called recitals. And you want to have something like this in your contract. And it explains that each of these people have brought something to the table. And because they're each bringing something to the table and they want to collaborate, there's a few things we want to get straight. So what are those few things? The relationship. It's their intent to collaborate and to use their best efforts. Second of all, we don't know exactly what the value of our services are, but we're going to negotiate in good faith. What are the credits? You can see that they did sit down and think about the credits. And in this one, there was a screen story, a screenplay written by for creator 1 and 2. And the third one was very intent post-production supervisor. The reason I'm bringing this up is that before the digital technology, I don't think I would have ever seen a collaboration like this in a collaboration agreement. Generally speaking, you would have seen two writers sit down and have a collaboration agreement, but not necessarily with someone who was in the technology area. So what I'm trying to let you know is that anything is possible and you can deal with anything. They're talking about their costs, talking about that they equal distribution of profits. And number 3 was joint ownership of the project. So the point of this agreement was to get a piece of paper that specified that these 3 people, although they were bringing very different elements to the table for this project, had decided that they were going to be equal partners. And why do they have this collaboration agreement? So that when they move forward and they find a potential financier or buyer, that it's already in writing that they're equal partners, that the buyer or the financier isn't going to try and cut one of them out. that they know what they're bringing to the table. And that was the value of this. It basically lets everyone sleep at night. So this collaboration agreement, however, does not mean that you don't take your material and register it for copyright. And in the present instance, there was literary material. There also was some kind of I'm just going to say demo material, audio visual material, and it was all registered for copyright protection in the U.S. Copyright Office in the name of all three. They had not set up a company. I believe in here that there's the intention to set up the company. I'm not sure if they've done it yet, but the reason that this agreement was so important is that if they end up at a Netflix or an Amazon or an HBO Plus, whatever the situation is, there is a registered copyright intellectual property which must be optioned before it moves forward, and that has value. So I highly recommend for anyone that they do this at the beginning stages. The next one that I did was a totally different, almost very traditional documentary where there were two parties, or I guess there are three. They were coming together. One of them had done some extraordinary feat in the world, and they wanted to make a documentary. So basically, the same kind of thing. They sat down and they said, Jane Doe was the person who, I'll just say, climbed Mount Everest. John Smith was the director that she chose, that she wanted to do this project. And the other one was the producer who was pulling everything together. So we had a very simple collaboration agreement so that when they went to Netflix, agents, whatever, that it was clear who was doing what. And it served that purpose. Now, by the way, both of these collaboration agreements do not mean that when a financier walks in, that they may want something different than what's there. So you never know what's going to happen in the real world, but at least these people were able to move forward, comfortable knowing what the relationship was and what their expectations are. Again, this is not copyright protection. It just defines the relationships between the people. So you say, oh, this is all great, but someone asked me that they love my screenplay and they want to go shop it around. So now what I want to talk to you about are the really almost a seismic shift in what is going on in the business with shopping agreements. I've practiced law long enough to know that years ago, if you said to someone, I want you to give me a free period of time so I can go see if I can set up the project and find money to produce it. They think, oh my gosh, what are you nuts? We're not going to do that. But basically, so much of the business works that way. What is a shopping agreement? In the one that I put up here, and forgive me for my tongue-in-cheek sense of humor, our writer is William Shakespeare. A producer basically says, hey, look, give me a period of time. Give me 6 months, give me a year, give me 3 months, whatever it is, to go out there and see if I can make a deal. And if I do get a nibble from a bigger fish to finance this project, I agree. We'll sit down at the table and we'll negotiate. And oh, by the way, in the meantime, you're going to give me the right to do development materials and create materials that I can use to help enhance the saleability of the project. So if you think about it, if you're a producer and you find a screenplay that you really like and you want to go out and sell it, but they don't have a pitch deck, you're going to want to put together a pitch deck. So you're going to want to have the right to do that. You're going to want to have the right to sell the screenplay, to take the screenplay out. And you don't want someone else undercutting you. That's why, for the efforts of the producers, they are now asking for shopping terms. I've had them ask for, like I said, everything from 3 months to, I think about it, I've done one in 3 years, and from free and sometimes for money on the table. Most of the time, it's more leaning towards being free. Why? Because the producers will be spending money in creation of development materials and time and effort to go set something up. Now, in this one that I gave to you, what I said, if you look at number 4 here, there were some negotiated points here. We said, if it's set up, then the author shall be entitled to a setup bonus, a long form option purchase agreement, and we put a floor in for 2.5% of the budget and a back end participation and at least a credit for the property and passive fees and royalties for derivative productions. These are all very generalized terms, but kind of basic things. Now, I'm not telling you that people will always put in these floor terms in a shopping agreement, but I have done it many times and found it very, very helpful. I will tell you that, and look at B, the producer, the one who's going out and trying to sell this project to the financier, puts up front that he wants an executive producer credit and a company credit and a fee and a back end and attachment. So in this particular agreement, the people have said, okay, we know what we want. We know that we're going to go try and set this up at a studio or set it up for independent financing. And author, you know what you want. You want a fee, you want credit, you want a back end. I know what I want. I want a company credit. I want a producer credit. I want my fees and back end too. So let's put this in the agreement and agree to it. Not a bad idea. I can tell you that I have done a number of pictures that have gotten made that started out with shopping agreements. I do a lot of international work. I've done this. In fact, I can't tell you what it is, but there's a major picture that's coming out that I had the great pleasure and honor of working on with major A-list, top-of-the-line people. My role was just really small, but I want to tell you, it started 7 years ago with a shopping agreement. So it's not impossible for those things to happen. I also have worked on something, interestingly enough, that was a co-production between an Eastern European and a Chinese company that, again, started with a shopping agreement. And I think that the reason that these things were able to move forward is that when the producer went to the money people, whether it was independent, in both these cases, there were studios involved, the setup was at a studio. The studio knew what the bottom line was, and it made it easier for them to make an offer. So don't be surprised if someone comes and asks you for a shopping agreement. You'll always see in there that there is an obligation to act in good faith and not to do things that are injurious to the general mission. But nobody has the right to bind the other one without a written agreement, which is good for everyone concerned. On number 5 on this agreement, this is a really long post-term obligation. I've seen them run from 3 months to 2 years. And you say, what's a post-term obligation? Let's say a producer comes to you and says, I want a shopping agreement. I need a year, COVID's going on. Maybe I need 18 months to go out there to the market and get this set up at a studio. And, but if nothing comes of it, and in the next year, you make a deal with that same studio, I'm attached. That's a non-circumvent clause. This is where I think you have to look at these things very, very carefully and see who you're talking to and what they're doing. I have become more focused on this because the way that life has changed and that we're all using digital technology and it's so simple. If you think about it on a shopping agreement, someone could send out an email to 100 people and make a claim that they have contacted those people. And then if nothing happens during that 12-month term or 2-year term, come back later and say, hey, I'm attached to this project. So I'm just telling you that is something to look at very carefully. Everything depends on the facts and the circumstances, what's being developed, what the producer is bringing to the table, what they're putting in, who they're going to. Now, what I am doing in my agreements, I am making it, again, depends on a lot of different circumstances. But the last shopping agreement that I did, the producer who wants to go out with the project has to come back to the rights owner and get approval for every third party that they're pitching to. And we have to have a list. And if we say no, they can't go out to them. Now, that may not work in your circumstance, but what I'm trying to point out is that it can be done and it's something to think about. The rest of this contract, I think I should bring up to you as rights holders. You will always, always be asked to make representations, warranties, and indemnities. That's legal language that basically says, I'm the writer and I guarantee you that I own this property free and clear of any liens or encumbrances and nobody's suing me. It's like a piece of property. This is intellectual property, but if it was real property, you're making a rep and warranty that there isn't a lien on the property. Okay, you're making that rep and warranty. And if it turns out that there is a lien on the property and I didn't tell you, I will indemnify you for the costs that you will incur as a result of that. So why am I saying these things to you now? It's another reason for you to be able to prove clean chain of title in the U.S. Copyright Office, because any lawyer on the other side of the table is going to do a quick search at www.copyright.gov and see what documents are on file there, or whether you've registered your script for copyright protection. And also, too, these reps and warranties are necessary. Since I don't have people here, I don't know if you're going to think this is funny. I hope you do. But when I came to Hollywood, I used to tell a joke that I thought I was going to know nothing but movie stars. And instead, I know nothing but insurance brokers all over the world. Why? I would have never thought that this is such an insurance intensive business. And it is. And what does that have to do with reps and warranties? Well, when you're producing a film, distributors require that the producer obtain errors and omissions insurance. Basically, that's an insurance policy that says that if anyone comes out of the woodwork and sues and says, hey, you don't own that property, I do, that's my script, or you copyright infringement, that there's an insurance policy that will pay for the lawyer to defend the suit and to settle it and get rid of it. So if you don't have reps and warranties from your writer, you're not going to get E&O insurance. And on that note, whenever I talk about insurance, I will tell you the other twist here is that if you're writing something that involves a true life story, there's a little bit of a higher bar involved here. You can't just do a true life story without having a life story agreement, or else you're going to have all sorts of issues. So if any of you are thinking about that, I recommend that you consult with a lawyer, because you want to have those rights in tow before you go out there and try and sell anything. So now the last agreement that I'm talking about is the literary option purchase agreement. This is the kind of agreement that has been used for, oh my God, 50 years, 100 years, since Hollywood started. It actually is formulated on real estate, again, property. In this situation, and I'm going to ask you to contrast it with the shopping agreement. In a literary option and purchase agreement, the producer says to you, writer, I'm going to give you X amount of money. I'll just say $1,000. And for the next year, you're not going to be able to do anything with your property. I have an option on that property. And then you're usually going to see an extended period of time for another amount of money, maybe even another extended period of time for another amount of money. And then other extensions for force majeure, or in the event you're in the middle of negotiations, you might have a 30-day extension. And all the producer has to do is exercise the option, which is usually by the payment of a fee, and the producer owns the property. Contrast that with the shopping agreement. In the shopping agreement, the producer has an exclusive period of time in which to go out and set up the property, but there's been no hold on the other underlying property other than that agreement that they won't go out and sell it. I used to have a friend who would call this, one of my mentors would call it a hunting license. It's a license for the producer to go out and try and set something up. If the producer gets a deal and wants to make the movie, then in a shopping situation, they have to go back to the writer and negotiate a deal. In an option purchase agreement, however, all the terms are negotiated up front, and all the producer has to do is send that check, and they own the property and they can move it forward. And I can see on the screen here, you see short form option and short form assignment. In an option purchase agreement, these documents are at the end of an agreement, and the property owner, the writer, will be asked to sign those documents. The first one, short form option, will be filed when the agreement is signed. It puts the world on notice that there's an option on the property. And where is it filed? The U.S. Copyright Office. So anyone who goes to the Copyright Office is going to know that that property, the brilliant story, is optioned by the brilliant producer. And then there will be in that contract somewhere that says that the assignment may only be filed and is only valid when the option is exercised. So when the producer pays the money, they file that short form option with the U.S. Copyright Office. These are part of the documents that will constitute chain of title. Now, in a shopping agreement, you don't have that. So another point is that an option purchase agreement is a legally binding agreement that is more useful to the producer. And it is better for the producer because all they have to do is pay the money. I'll get to what the money is and what these all these numbers are. We can talk about that because I know some of you have questions about things like this. But in a shopping agreement, the producer has to go back and negotiate. However, in an option purchase agreement, I have to tell you as a lawyer, they are the most complicated, not so intellectually difficult, but they're complicated. There's lots of different things to negotiate, and so it costs money. So producers oftentimes have leaned towards an initial shopping agreement so that they can test the waters without expending a lot of money, both on an option and on lawyers. So that's why the shopping agreement has become so popular. Now, by the way, in connection with this big movie I referred to, yes, it did start out with a shopping agreement, but when the producers saw they had something, they went to an option purchase agreement and we negotiated it. So let's talk a little bit about the option period. There used to be, you might say that a calculation of 10% of the purchase price would be an appropriate option payment. Yeah, but I've seen it all over the map. I would say that if you have a screenplay that is unknown, it wouldn't be unusual for that option to be $1 or $50. So again, all over the map. The purchase price, on the other hand, it is very, very standard to say 2.5 of a budget with a floor and a ceiling. Why? Well, producers are educated, or at least in my generation, that the intellectual property rights upon which a movie is based is 5% of the budget. And that 5% is divided 2.5% to screenplay and 2.5% to underlying property. Now, that's just a rule. It has been broken a zillion times, but it is not unusual for you to see 2.5%. Now, if someone's going to do an original screenplay, maybe that number for a purchase for an intellectual property would be 5% of the budget. But I can tell you, I represent a lot of producers that I always go in lower because you never know that screenplays are going to be rewritten. So just keep in mind, if somebody wants to pay you less, I'm going to say than 2% of the budget, that's too low. But 2.5% of the budget with a floor and a ceiling, that's not unreasonable. Second of all, I also think, I know that there's writers in this group. I think you should familiarize yourself with the rate sheet of the WGA. Now, you're not all WGA writers, and the WGA can be very, very burdensome. However, it gives you guidelines. It gives you excellent guidelines of what prices are. So if someone's offering you, if you look at their ultra low budget agreement and the script is going for $30,000 and someone is offering you $10,000, you know that they're really, really, really lowballing you. So that's what I have to say about the option prices. Contingent compensation. This is a very, very difficult issue at this point in the entertainment business. I can say that it used to be, with a theatrical market and a very vibrant theatrical market, and it may come back, who knows, that there were different formulas of contingent compensation. As a first-time writer, you can't expect to get anything more than net. But there was net receipts and there's adjusted grosses, and there's also theatrical bonuses and all sorts of ways to demand additional compensation on the back end. COVID has changed so many things, that and streaming. And generally in the streaming world, there is no back end. So I'm still seeing contingent compensation being offered, but I'm seeing people going back to a formula that's more like net profits, and we'll see where it goes. So that's all I have to say. As a first-time writer, you can insist on the back end, you can negotiate hard, but so few movies ever reach that point. And as far as television, that's a whole different market. And again, with the streaming media being so prevalent and the syndication market just basically not existing, or a whole different thing, I don't know how much back ends there really are for writers at this point. But the next thing I have to tell you is subsequent productions. If you're a first-time writer, I have to tell you, most of the offers that come on my desk for writers are basically for a buyout of all rights. Almost never do I see one-picture licenses. I'm making a deal for a movie that's based upon a Broadway play. They will give a one picture license. But if it's going to be original screenplay by a first time writers, generally the producers insist on buying all rights. The issue is whether you could get money for remakes, sequels, and derivatives. I would say that you have to ask for it and you have to be insistent that you want it. There is nothing wrong with getting 50% of the original compensation that's paid for remakes and sequels. And for television productions and series royalties and things like that, you can see some numbers that I put in there. These numbers are always going to be subject to change as the mediums themselves are changing, but I don't think that's a bad thing either. You can ask for it. But trying to hold on to those rights, that's a whole different situation. The only, in the last, I'm going to say, I don't know, 5 to 10 years, the only people who are holding on to their derivative rights are properties that are established in another medium. I think someone asked a question and used Stan Lee as an example, but his properties were comic books turned into movies. And I've done a lot of that. I work a lot in animation and I've seen a lot of that. And yes, they are giving one picture license and producers are taking one picture licenses to make one movie with rights to make derivatives. And you negotiate all those terms. But for the first time writer with an original screenplay, I just would say that who's ever going to invest in your movie, that they're going to tell you that they want those derivative rights. Your job is to see that you get payment if those projects ever come to fruition, and then maybe even the opportunity to write. So we'll leave it at that. And then we should talk about a writer agreement. In a writer's agreement, what are you going to negotiate? Well, first of all, what I just said, it's unlikely that there is going to be a one picture license. It's more likely that they're going to buy all motion picture rights into the screenplay. So if that's the case, then what your job is to find out what additional services you're going to get and what kind of royalties. We already talked about that. This one is a service agreement. Okay. Steps and delivery. I think it's really, really important to be clear how many drafts of a screenplay they want and when they want delivery. Now, I know that most writers usually do more than they're asked for. I mean, it's just part of the job. But a producer needs to be clear about what they want and when it's going to be delivered, like a treatment, a first draft, and one set of revisions. Is there a polish too? And to polish, again, when I'm using these terms, I suggest you go to the Writers Guild agreement and look at their definitions. It's very, very helpful because they set out what these things mean. And there's no reason you can't refer to the Writers Guild without being a member. And I bring this up because I want to tell you that we do this, lawyers do this all the time in non-guild agreements. And the most important one is that we refer to the Writers Guild credit provisions. Because if I'm doing a non-union movie, non-WGA, and the writer says, you're going to give me screenplay credit, I scratch my head and say, well, what if we have to revise it? What if my client pays the money to you to write a screenplay, and then we take it to Netflix or Paramount or whatever it is, and they want a rewrite? And they want to rewrite with the Writers Guild writer. Well, the Writers Guild has provisions like the one that always sticks in my mind is if somebody doesn't write 50% of the screenplay, then they don't get screenplay by credit. They have provisions for determining who gets credit. So I can put in an agreement that credit will be determined in accordance with the provisions of the WGA. However, this agreement is not subject to the WGA and their writing credit procedures. So it means you look to the agreement and you can figure that out. That can be very, very important. So I encourage all of you to do that. And it's important also, I don't know, some of you may be producers, to know that. Why? Because as you're moving forward, you never know who's going to demand what rewrites. As a writer, you may demand that you do a rewrite. You may get it, you may not. I don't know. But anyhow, we'll move on. Fees are fairly simple. Writing services first priority. Generally speaking, that language means that you're not exclusive, but you have to pay attention and it's first priority for the producer during the period of time that you are doing those specific writing services. And number 8, screen credit. In this non-union, I did not refer to the WGA. This was just a plain simple, what is the screenplay? What is the writing credit, screenplay by or written by or whatever it may be. However, I just encourage you as writers to think about that and to understand how that works. The standard terms and conditions is the typical blah, blah. The last document, the short form certificate of authorship. I want to talk to you about this. This is a document that basically says, producer, you own everything as a work for hire. It's a document that the industry has adopted over the last, I'm going to say, couple of decades actually, to prove ownership. It is also a document that they use wide so they can file this or show a distributor or show anyone who's contesting what ownership is without revealing all the terms and conditions of a contract. So don't be surprised if you see a certificate of authorship at the end of your contract and you say, why do I have to sign this? I already made these representations and warranties. I already talked about copyright in the long form. That's the reason why. And it's really not a bad idea. I will tell you that when producers are delivering independent films, and I've done a number of them, to distributors, that they often will ask for the certificate of authorship, even though there's a long form contract, just because they want to have that document in their file to prove that the writer does not own the screenplay, that the producer owns the screenplay. So enough of that. And I think it's time for me to answer questions.
Yeah.
Stop talking and answer something.
But thank you for such a thorough explanation of these documents. And yes, I think it's a great time to move on to the questions. What things should a screenwriter look out for in deal memos and options?
Boy, that's a big, broad question. I covered a lot of those things in what we have talked about. I would say in these things, in deal memos, interesting that you bring up that topic. A deal memo is generally subject to a long form agreement. I think in terms with writers, what happens is that people will do an extremely abbreviated deal memo, say, okay, everything's set, writer, you can start writing, and jump into a contract immediately. Because as I said at the beginning, there's no transference of copyright without a written agreement, and a deal memo generally doesn't have that copyright language in it that says something to the effect that writer agrees that the results of proceeds of services hereunder is a work for hire as such term is understood in the copyright law. And if it's not, he hereby assigns all right, title, and interest to producer in the world in perpetuity. So that kind of language isn't in a deal memo. And if a producer doesn't have it in there, they're kind of silly. They're walking on thin ice. So I would say, I don't know, if I was a writer and somebody gave me an incomplete deal memo, I would look at them and say, what kind of producers are they? So, what can I tell you? Don't they have a lawyer? And then in options, I would say, just keep in mind that in the option agreement, all the rights are in the producer. All they have to do is pay you and exercise an option, and they own the material. So make sure that you're absolutely okay with all those deal terms. And if it's an option of a screenplay and you want to be able to do the first set of revisions, like a producer options your screenplay and they're going to take it up the food chain to a major studio, and the major studio wants revisions. If they like the screenplay enough to buy it, then maybe they should like you enough to give you the chance to do the first set of revisions. And then, is there a price negotiated? That's what I would look for.
If a management company is asking you to pay for their services, are they a legitimate company?
Excellent question. So I started my career at ICM. And so it was a long time ago, but you can imagine that there were nothing but people who really knew the business inside and out. And one of my mentors said to me, listen, kid, if you ever see managers who charge you for their services, run. And I never forgot that. So are they legitimate? You know what? I know some people who do this, and I know they've been a little bit successful. I don't think that they're successful in the big picture. I think that there are people who have set up writers for independent films and smaller television jobs who pay for services. Do I like it? I still haven't gotten over it. No, I don't like it. So I'm not sure that that's a good alternative. If you're going to enter into that agreement, I think you really need to look at it very carefully and see what are they giving you for what period of time, and cap your involvement with them. If they don't deliver, you need to be able to cut them off without owing them percentages down the line. So my point is that no, it doesn't make me happy, but better look at that agreement real carefully. Okay?
Is copyright invoked by just stating on a document that it is copyrighted, or by the use of the circle around the C?
You can claim copyright in anything, and a lot of people will do that. And it's real funny that you asked this question, because I had this like I would say spar fest with someone who was doing this, and I kept saying, "Stop it, stop it." In reality, the C in the circle is really only valid if you're registered in America, if you have a registration of copyright. But everybody violates that. We used to be in America a jurisdiction that said copyright would only be valid if you registered for copyright. But we changed with the rest of the world in the 70s. And so now, no, you can assert copyright ownership, but you can't sue. You can't sue for infringement of copyright in the United States unless you register. What's the bottom line here? Register your copyright, okay?
For the documentary collaboration, does that mean the Jane Doe has to copyright what she did, her great feat?
Copyright attaches to creativity. And a fact that somebody climbed Mount Everest is not creative. If she wrote a treatment about her experiences climbing Mount Everest, that would be copyrightable, but not the mere fact of it.
Could you clarify the order of agreements? If I have a TV show or feature that I want to sell, which agreements should you use and when?
Well, if you have a TV show or feature, what I still don't understand is, from your question, you have a vision of a project, but do you have a treatment? Do you have a screenplay? Is that embodied in pitch materials? All those things, I would suggest you should copyright. So you can put C in a circle and refer to that. And the order of agreements, when you say you, well, are you going to sell it? Are you going to be out there? If you go out to sell and you want to submit it to CAA, they're going to send you a submission agreement. If you want a producer or a known producer to go out and sell it, they're probably going to want a shopping agreement. And if it's incredible and and you've got a producer who wants to option it, they'll give you an option purchase agreement. So it's not a matter, what you have to do as a intellectual property owner is to make sure when you're going out there that you have protected yourself. And the reason I gave you collaboration agreements, because it shows that when a couple of people get together and they come up with an idea, that they at least agree amongst each other what their rights and responsibilities are, what they expect from the agreement. But that doesn't mean that they still don't take their property and register for copyright. But as far as what agreements do you use, it's probably the other party that's going to be giving you the agreements, depending upon where you're going.
So you mentioned something about protecting your copyright. When you're selling a show or movie, do you mean you sell the show but keep the copyright? How would that work?
It's a great question. The television industry for years, because of what we had was called financial syndication rules, was working on a licensing basis. Networks would license shows from producers. But because of the FinCEN rules being overturned, and because of what I was talking about, vertical integration, blah, 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 the Netflixes of the world can develop, produce, and get to the public all by themselves. And they are in a model now where I'm going to say 90% of what they're doing is owning copyright. The reason I suggest that you protect your copyright is to force who is ever looking at your property to recognize it and pay for it in the underlying materials. Most of the agreements that I'm seeing are not license agreements. I can't say I haven't done it. I did a animated series that's on Netflix. It was a license deal, but it's not. The rule of thumb now are the organizations that have the ability to make films are insisting on owning the copyrights.
Could you clarify if both option and assignment are filed with the Copyright Office?
Yeah, the option, absolutely. In fact, I'm sitting here on my desk looking at two that need to be filed right now. Oh, and by the way, the irony about filing documents with the Copyright Office, you have to do it by mail. You have to send them hard copies. It's not an online transaction. But anyhow, the answer is yes. But the assignment, you wouldn't file until the option was exercised.
Do you have any advice for reaching out to producers and production companies? And what would you say in an email?
Oh, I have to tell you, I laughing. Don't take it from me. I say that I couldn't sell a gourmet meal to a starving man or woman. So when it comes to sales advice, I'm not the one. Although I do send out material to people on their behalf, to people who are looking for material, if it's the right circumstance. You know, there's nothing in particular to say. I know that sounds silly. I think you have to be as succinct as possible. I think you need to get your elevator pitch down and say it in 2 sentences. I know that when I'm in the middle of a busy day, if I get a long email, it's like after the second paragraph, most of the time I don't want to read it. So hard to say. I have to tell you, there's a resource list that I gave to you. And there are some resources that are available online that I think are really, really great. And in number 5, there are all these internet resources now for you to read and to find out information about selling your script. The 2 that I've seen, one's called Script Pipeline and the other one is Stage 32. Go to that resource list and see what they have to say. And by the way, the list also has the Copyright Office and unions and all sorts of trade information. There's just so much good stuff online. And I mean that sincerely. It's just wonderful that these resources are available. So when should you start working with an entertainment lawyer? Yesterday. But actually, the minute that you're going out there, if you have a relationship with someone, listen, we're all very busy, but I also do take time out and talk to people. It's not that I can't talk to somebody and give them some simple advice. But I think the minute that you want to move forward with a project, that you need to think about having a lawyer. Okay?
Can you talk about fiscal sponsorships?
Fiscal sponsorships. I'm so glad you brought that up. I have a sticky here
Oh,
that I had on it that said fiscal sponsorships. I think the fiscal sponsorships are a really interesting resource. I have worked with fiscal sponsors in the past. I'm working with some producers who are using them right now. How does it work? Let's just say the Documentary Association. A producer will go to them and will propose a project. If they accept that project, then sponsors can go to the IDA, give them money. The IDA takes its small percentage, whatever it is. I really don't know off the top of my head, and gives the rest to the producer. Today, what's happened, I'll just tell you, I have a little movie. When I say a little movie, I don't think it's $500,000, but these kids have been incredible in putting together. And they have someone of means who loves the movie, loves the subject matter, loves what they're doing. And they are going to a fiscal sponsor and she's writing a check for, I don't know, $25,000, $30,000. That will go to the fiscal sponsor. She will get her tax deduction. The fiscal sponsor will take its small amount of money for this service, and the rest will go to my client to help them finish their film. So it's a wonderful, wonderful program. You should look into it. Again, use the internet. I know San Francisco Film is one, International Documentary Association. There's a number of them out there.
can you share more about who you make the agreements with? If you want to shop a script for a TV show or a feature, who should you reach out to? Production companies, studios?
Well, a production company or a studio is not going to enter into a shopping agreement with you. Those are generally producers, people who have small or medium, sometimes large track records, who will want to tie up your property, and they will go to the studios and networks. So basically, and the word producer, it comes from the Latin. It means lead it forward. And that's very helpful to remember that, because there's so many different kinds of producers. If you see a little motion picture with 25 executive producers, it probably means people who have invested. It's someone who brings something to a project that has been invaluable. I am a co-producer on a project. What did I do? I know what I did, a lot of the business work that helped this international co-production move forward. It doesn't mean that I optioned the property. It doesn't mean that I entered into a shopping agreement. But people who go out and sell, generally they're producers, and they're the ones who are going to ask the rights holder to enter into a shopping agreement.
Generally speaking, how often could one of these given deals go bad? This is a great time to remind everybody that CLA has a mediation service that brings two or more parties together in case you want to settle an argument or a dispute out of court. But Carol.
Oh, Sammy, that's a great question. Well, I've got to say that they don't always go bad, but people just, like marriages, dating, they fight. It is what it is. So you try and protect yourself. That's all it amounts to. And yes, thank God CLA exists, and you have a place to go to attempt to resolve it.
So if you're writing a script for a friend who's paying you, what kind of agreement would you recommend?
One for money, and the one who is paying is probably going to want a simple work for hire writer agreement.
A work for hire would
Well,
would allow, but that would give the copyright to the friend,
that would give
not
the copyright to the
person
yeah.
writing.
Now, if that's not the intention, then you have to sit down and just take a deep breath and
Yeah.
go through it and figure out what are the rights and what's the intention of the parties. Okay, everything's negotiable.
Mhm.
It just has to be. I suggest that you have clear understandings before you go move forward and get third parties involved in order to avoid disputes.
How do you find an independent entertainment attorney, agent, or manager? And which are the people you need to contact the most and how to approach them?
Okay, let me segregate this out. Over the course of years, lawyers have started working on percentage basis. Okay, it wasn't that way always. There still are a number of lawyers who work on a fee basis. I mostly work on a hourly fee basis. And the reason I'm mentioning that to you is that when people work on a percentage basis, like these big law firms that handle movie stars, they're very highly specialized and they don't necessarily have time to take on new clients. It's just kind of a different business. They're more like agents and managers than they are like traditional lawyers that you find one, you pay them a fee. So how do you find an independent entertainment attorney? I guess CLA is a good start. I would say also ask for recommendations. As far as the agent and manager, boy, that's a much harder thing. I have a client, I'll just give you an example, who has credits. And the agents, with all the turmoil in the agency business, and God knows there is nothing but turmoil with ICM being acquired by CAA, this consolidation, her agent has basically quit the business. Where does she go now? How does she get the new one? Does she stay with the old agency? Does she find a new manager? Do they want her? Not easy. I think, again, would you please look at Stage 32 and this other group, Script Pipeline. These people at Script Pipeline will read material, and if they like it, they are known to help people get agents. There are also organizations. There are women entertainment. There's Women in Film is this big organization for professionals, but there's a lot of other younger film organizations. I think you have to go online, find them, and start circulating in the industry, going to seminars, meeting people. You just have to be out there. Now, yes, you can make cold phone calls, but I know people have been extremely disappointed in that cold phone call. But do it. That's all I can tell you. It's a hard business, and that's why I say that you've got some of these online resources. Familiarize yourself with it. And as far as lawyers go, most of us lawyers like me, I will jump in when you have a deal. But before you have a deal, I'm not sure that I'm there to advise you because there's nothing for me to look at, nothing for me to negotiate. If you think you're going to put a lawyer on retainer to help you find an agent, that's one in a million because that's not what we do. Okay.
Do international producers respect US copyright laws?
Oh, they have to, absolutely. And we have to respect their laws. Copyright exists around the world. I do a lot of international work. The answer is yes. And that's why I said that our US Copyright Office is incredible because it's the chain of title verification for the world.
What kind of agreement do I need with my cinematographer in order to retain my copyright?
You need a cinematographer agreement, is a work for hire agreement. There's a short one called a certificate of engagement that is like the certificate of an authorship. It basically says that the producer, the hiring party, owns all rights, and that's it. You need that. And also in that, you can also put in what his credit will be. And the consideration credit is deemed adequate consideration for the transference of those rights. But, we have our ways of doing it. $1, another good and valuable consideration. But certificate of engagement, simple one-page agreement.
Is it okay to put log lines of your scripts online or on your website? Or do producers look down on that? Or is that not legally sound?
Well, it depends on the log line. I would say most of those are so simple that they're not necessarily protected by copyright. I don't like that. I mean, it's not something I would suggest that you do. It just doesn't feel right to me. To a certain degree, you're giving ideas away, and I don't like that. So why would you put it on your website? I mean, what's the point of that? Are you putting it on the website so you're going to drive business there so that you can get an agent or something? Better copyright that website, for God's sakes.
Can a work for hire agreement be formed without an explicit written agreement? Is there such a thing as an implied work for hire agreement?
I'm going to say no, but I would have to go check case law. To the best of my knowledge, all work for hire and transference of copyright has to be in writing. I don't believe there is anything as an implied, but it's an interesting question. There may be some oddball case, but don't even go there. Okay. Get a written agreement. Okay.
If you have a shopping agreement with a producer and they reach out to the buyer production company who wants to do the project or buy the project, how does the agreement process work from there?
Well, then the production companies, if it's a shopping agreement, so if you think about it, in the option purchase, the producer just pays, okay, and all the deal terms are set up front. But in the shopping agreement, there's all sorts of things that aren't set. Then they come back to you and they start negotiating. Then get used to hearing the word your lawyer's calling.
Should you copyright a logline/idea/high concept for a screenplay feature? I don't believe you can copyright an idea.
Ideas are not copyrightable. Copyright law in America is the subject of many cases. It is not as simplistic. Ideas are not copyrightable. They have to be embodied in a tangible medium and they have to have sufficient creativity. So the answer is probably no. Now, if you have a treatment, that's a different story. But logline, I don't know, boy meets girl, no, I don't think so.
Are log lines copyrighted if the script is copyrighted?
Actually, it's an excellent question. I'm glad you asked that. There can be elements in copyrighted work that are not the subject of copyright. If you think about it, copyright applies to the entire work. It doesn't apply to an idea in the work. I mean, think about a cowboy movie. A boy meets girl, boy dumps girl dumps boy, whatever, those log lines, that concept may be in a zillion movies, but it doesn't necessarily mean it's subject to copyright. And it's the subject of a whole other discussion. So the answer is not exactly. And you know what, just for a little bit of humor, the answer to all these questions is maybe. Okay.
Yeah, well, we definitely support, again, for copyright in general, like you have to, it can't be in your head. You got to find a physical or I guess musical, if it's sound, dance, whatever. You got to find a tangible way of creating it. And then you can talk copyright.
It has to be tangible. And you know what? Go to the U.S. Copyright Office. Again, it's on the resource list. And they have tutorials and explanations. And it's really excellent. They do a great job.
Well,
okay?
Thank you so much for having us, Carol, or for gracing CLA with your knowledge and expertise, and also for providing all those documents that could be freely shared with everybody. Thank you, Carol. Have a great evening.
Thank
you, everybody, for coming tonight, and we will.
Thank you all.
Yeah, thank you.
Okay.
Have a great evening, everybody. Enjoy. Thanks for coming.